Number one, I want to thank all of you for participating in this webinar on early neutral evaluation. I hope that when we finish that you'll be as excited about trying this new hybrid method of alternate dispute resolution as I am. I think you'll find it extremely beneficial. I guess I would be remiss if I didn't congratulate Debbie Weaver for entering into a transaction in which I guess her interest in Alaris was sold, and she will continue, though, as the CEO of the Alaris business unit of Lexitas. So congratulations to Debbie, and also congratulations to Jennifer Matthews, who basically will continue under that new structure as the director of ADR. So we'll give all of them a hand with respect to that. We do have a PowerPoint presentation that we'll be going through. Personally, I will tell you that I don't really care much for PowerPoint presentations, but I'm going to supplement the PowerPoint presentations with some of my experiences that I've had as it relates to mediation. A lot of you may seem that some of this material is something you've already heard. That may be the case, but I think you'll find as we go through the process as to what constitutes early neutral evaluation, that it's significantly different than just traditional mediation. Obviously, it's not arbitration, but I think you'll find that it's an extraordinary alternative that you can pursue with ADR processes. It's without question, a hybrid form of alternate dispute resolution. The concept basically originated in the United States District Court for the Northern District of California. It was originated by a magistrate judge that got a team of lawyers together and say, hey, let's try this new process. And the reason why they did was because they had found out that the clients of lawyers kind of felt like they were outside the realm of what was going on with respect to their litigation, whether they were a plaintiff or a defendant. And they kind of wanted to resolve that problem so that clients could be more active in the participation with respect to mediations. And for that matter, if the mediation did not result in some kind of a settlement, that they would actually be involved and understand what's going to go on at the trial level, which, as all of us know, as attorneys, we basically are talking to the other lawyer on the other side. And sometimes that does not get communicated well enough to our clients. I will tell you that Judge Brazil, who is the magistrate that I told you had formed together a team to develop early neutral evaluation, has written a book that I will certainly recommend to you. I've read the entirety of the book. I think it's very valuable. Appropriately so, the title of the book is Early Neutral Evaluation by Judge Brazil, spelled B-R-A-Z-I-L. And it is available on Amazon, and you can get it on your Kindle if that's the way you would prefer to review it. Judge Brazil has been extremely helpful with respect to the Supreme Court rules as it relates to early neutral evaluation. And as a matter of fact, I'm going to give you a website that I think you'll find to be important. And it is a website to the rules of the U.S. Supreme Court of the Northern District of California. And that website is www.C as in cat, A, N as in November, D as in December, .US courts, that's plural, .gov. And in that Supreme Court ruling, I think you'll find it's extremely beneficial because it does go through some of the steps that I'm going to mention to you today on how to get to early neutral evaluation. Before we get there, I want to make a couple of comments to you about our process today. You may think as we go through here that I'm being critical of lawyers. Believe me, I'm not being critical of lawyers. There are some things that basically peeve me as it relates to trying to get this process moving forward with mediation. I'm sure you have some items that cause you some concern too as you go through that. But notwithstanding that, I think if you'll bear with us for a little bit, you'll find this to be a very helpful process, one that will be challenging, I will admit. about being critical of lawyers, I can't really be critical of lawyers because I'm a lawyer, as well as all three of my children are lawyers. As a matter of fact, two of my daughter lawyers have married lawyers. So when we get together for a family occasion, you can imagine you've got 5 or 6 lawyers that are, making input with respect to the discussion. While early neutral evaluation is basically a different concept. It is, let me see if I can go to the slide here. We'll get this up. It's not, just kind of go through this slide a little bit, but I want to tell you that early neutral evaluation is not mediation, and it's not arbitration. As in mediation, it is non-binding and it's confidential. However, the format, which is one that I don't think has found its way literally, except maybe in St. Louis, to the Midwest, where people are actually using early neutral evaluation. And that's one of the reasons why I kind of wanted to be a presenter for Alaris on this matter, and to let all of the neutrals understand, and the lawyers understand, that this hybrid method of ADR is certainly available. The thing that is going to be different for you is that, as in arbitration, in early neutral evaluation, everything is open and in a joint session. And we'll talk about that a little bit later, and I would certainly invite your comments as to how we go along. One thing that I think all of us understand that are mediators, and maybe even counsel understand, that in the traditional mediation, that we start out using what I call the facilitative method of mediation. And when we go through and kind of define what the facilitative method of mediation is that it's, one that basically is trying to enhance the communication of the parties and arrive at a settlement. And in that method of communication and trying to arrive at a settlement, the mediator takes the role of just trying to facilitate the communication among the parties. And the mediator does not give his opinion or his advice with respect to any aspect of the law, doesn't point out any strengths or weaknesses with respect to either party's case. Basically, kind of, as I usually tell when I'm doing a traditional mediation, while I may be a lawyer, I'm not here with that hat on. I'm here basically to be a neutral and to hear the facts and circumstances and to try to help you arrive at a settlement. In early neutral evaluation, that's entirely different. In traditional mediation, in my experience at least, is I will try to start out with the facilitating method. But generally, as the day wears on and you get to what you think is maybe the end of the mediation session, I think most of us just naturally evolve into some aspect of the evaluation, trying to not get to an impasse, but trying to get the parties to basically find a settlement of their own dispute and make their settlement their own. Sometimes it works, sometimes it doesn't, but generally we're using the facilitative method and we're not using the evaluative method. That's entirely different with respect to early neutral evaluation. You, as the neutral, are basically there in the capacity of being an evaluator of the aspects of the case, the claims, the defenses that are asserted, and trying to give basically a second opinion as to what you think would happen in the event that this case went to a jury trial, or for that matter, to a bench trial. I think sometimes we overestimate, the importance of us as mediators with respect to doing mediation. Sometimes we mark that, how many cases did we settle? How many cases just went to an impasse and didn't settle? And we have a tendency, wrongly so, I will say, to determine the success of our efforts with respect to mediation as to how many cases that were settled. That's certainly not the case with respect to early neutral evaluation at all. I actually attended a CLE not long ago by a lawyer by the name of Ron Weisenthal, who is gave a presentation called Dealing with Lawyers as Mediators. And I think one of the things he said I thought was really important that we ought to keep in mind, that he said it's important for the neutral to understand that the future of the Western world will not change by what we do here today. He said, what we are trying to do is keep the lawyers and the clients from engaging in self-destructive behavior. And I think that's exactly right. By the way, we've got a poll up, you know, that you need to answer, and Kansas requires that basically you answer this poll. This one says, did you believe remote mediation are as effective as impersonal mediation? My answer to that is yes, but your answer basically will show that you're involved in attending this CLE so you can get credit for it. I think we've seen that one, so we'll go to another one here. And this one, you know, is basically you look at early neutral evaluation and say, well, why should I do that? Well, one thing is the reason why all of us want to participate in mediation is that, you know, if you're going to go to trial, you're looking at least in Johnson County and Jackson County, you're looking at probably 18 months before you actually get a docket setting so that you can go to trial. If you're looking for a jury trial, you're probably looking between 18 and 36 months. So one of the benefits of mediation that I think is really important, besides some other elements that I'll mention to you, is the timing. You know, from the standpoint of waiting 18 to 36 months to get your case before, you know, a judge. Well, we got another slide there. Before you get to a judge, you can get to mediation at a much earlier date. But I will tell you, one of the things that have been frustrating to me is that that lawyers, their dockets have gotten so crowded because of COVID-19 that it's hard to find calendar dates that basically, you know, you can get done. And so hopefully, you know, you can get the attorneys to agree on a date. If you can get them to agree on a date that is earlier than what they otherwise would have if they were going to go to trial, you save time, you save a lot of money. I've had mediations where I've had Fortune 500 companies that have sent lawyers from Dallas, Texas, from Atlanta, Georgia, from Miami, Florida, and they had to travel to Kansas City and basically be involved in a mediation in person. Obviously, that was before COVID-19. And with respect to a mediation, you basically resolve, you know, all of the issues with respect to the expense, lodging, and you know, going out to a restaurant to eat in order to be there for that particular mediation session. So you save time, you save expenses, and to some degree, you also basically are trying to get some of the uncertainty, you know, out of the process of going to the lawyers, because frankly, as an evaluator, where I'm in that process of early neutral evaluation, I'm trying to make a judgment as to what a court is going to do, what a witness may be persuasive to the jury, or to, if you're in a bench trial, to the judge. And somewhat, you know, you can reduce some of the uncertainty with respect to those elements as to the presentation of your client, what they're going to say, how they're going to say it, their demeanor, and it certainly is a benefit. So you've got cost, you've got time, and you've got other uncertain factors that are involved that you're able to resolve as far as the early mediation. See if we can get to the next slide here. And we are going to go into some detail about, you know, early mediation. Let me see here. As to, you know, the statutes and the case law and the Supreme Court rules, I would point out one thing is really important is to look at, I think we've got another slide here as it relates to, yeah, another one. I'll go back. 28 U.S.C. 652 is the citation that I would direct you to. It says, and I will read this because I think it's important. I do have some comments about it, and I hope you have some comments about it in the question and answer session. It says each district court shall. It doesn't say may or could or hopefully would. It says shall by local rule require that litigants in all civil cases, and keep in mind it's civil cases, consider the use of an alternate dispute resolution process at an appropriate stage in the litigation. So this particular statute is basically assuming that you're on a post-petition filing basis, and that at some time after that, it would be appropriate to enter into a mediation. I disagree with that. I think that basically most of us, when we have a case, and if we're a plaintiff, for example, you're basically going to write the initial demand letter to the opposing party. And in your demand letter, you're basically going to suggest that you've got a draft of the complaint or the petition that is in your hands, and you're attaching it, and you would like to discuss this matter before it goes any further and before you have to file the petition. And in that case, you get an opportunity to suggest mediation. One of my daughter's husbands, a lawyer, is a guy by the name of Dave Sanford, and I had the occasion to get his input with respect to early neutral evaluation some time ago. And basically, he said, that he always writes that demand letter, and to avoid this issue as to whether you're exhibiting a weakness when you ask to mediate a case, as the initial demand letter, he says, I suggest that we do mediation prior to the time that we have to file this case and the petition that is attached or the complaint is attached. Most of them are class actions in his case, but he's a premier plaintiff's lawyer and has settled numerous cases against very large entities such as, universities like Dartmouth, located in New Hampshire, against Fortune 500 companies, Walgreens being one of them. They're like 401k type cases and class action cases that he's involved in. And he basically, said, I think that's a very important thing to do, is to try to get to mediation at the earliest possible date before you engage in all of the discovery, all of the pleading motions, all of the motions for eliminate, all of the electronic stored information terms that you are going to pose for discovery purposes. But if you can basically handle those things in a mediation, you're way ahead of the game. I've got up here on this next slide about whether our local jurisdictions basically embrace early neutral evaluation as a process. Rule 17 of the Missouri Supreme Court, I think, is extremely well done. And I put up there what basically Rule 17 says about early neutral evaluation. And it describes E&E as a process designed to bring together parties to litigation and their counsel in the early pretrial period to present case summaries before and receive a non-binding assessment from an experienced neutral evaluator. The objective is to promote early and meaningful communication concerning disputes, enabling parties to plan their cases effectively and assess realistically the relative strengths and weaknesses of their position. While this confidential environment provides an opportunity to negotiate a resolution, immediate settlement is not the primary purpose of early neutral evaluation. Well, if it's not the primary purpose of settlement with respect to using early neutral evaluation, what are the benefits you're going to achieve by doing it if you don't reach a settlement? Well, the benefits are when you are able to see and hear the comments of the opposing counsel and what their allegations are and what the proof is they have behind the allegations, the elements of the proof. And you see what the damages are and basically are assessing the damages. It gives you an opportunity basically to enter into some stipulations or some agreements, prior to the time that you actually get involved in the discovery process of litigation. And that can help solve a lot of problems early on, rather than having those issues basically remain unresolved prior to the time that you go into an actual trial setting. But anyway, I would encourage you to look at that. Believe it or not, the Kansas Supreme Court repealed all of their prior rules with respect to alternate dispute resolution and, put forth and enacted their Supreme Court Rule 905 through 922. consisting of 44 pages of information, but in those 44 pages of information, there is not a reference at all to early neutral evaluation, which frankly surprised me, given the fact that our federal courts and generally the Missouri included basically have this included. I have here a statute also for Arizona, if I can find it. It is, well, the statute for Kansas is KSA 5-502, open parent H, closed parent. The statute for the Missouri Supreme Court rule, not a statute, but a Missouri Supreme Court was 17.01, open parent little b, open parent 2, closed parent. And in the Arkansas Code, it's under Title 16, Chapter 7. So if you're in one of those jurisdictions, you can look and see what basically that has to say. But it is, the thing that surprises me is that early neutral evaluation, I think, is so incredibly important rather than what we're doing right now in just a mediation session, because it gives you the opportunity really to have your clients, have you help your clients manage their own expectations with respect to the value of their case. So what is early neutral evaluation? And we're going to go into some detail here, so bear with me as to the process that we're going to go through that is different than a traditional mediation. It consists of a pre-session conference between the neutral and the lawyers, followed by a joint evaluating session, which the neutral prepares a written evaluation, places it in a sealed envelope, and then returns to the joint session and determines if the parties want to see the evaluation or proceed to a traditional mediation session without knowing what the evaluation is. So contrary to what my experience is in the Midwest, at least in Kansas City and other areas around the Midwest, that most lawyers not only don't want to have or make an opening statement, they don't even want sometimes their clients to see the opposing individual that is involved. Many of the cases, for example, in Title VII, which are discrimination cases on the number of areas where discrimination is unlawful, it's an emotional thing. It's emotional, almost like a divorce, especially if you had a plaintiff that basically was fired or discharged or not given the appropriate pay, or discharged because they were a woman instead of a man, or discharged because they think it's a race-based type issue. And so it can be emotional in an open joint session. But I will tell you what I do at least is that in my traditional mediation sessions, I talk to the attorneys in advance and I ask them if they would like to make an opening statement. Most of them basically say no. By the way, there's another poll up, so it'd be appreciated if you would answer. I think the answer for me is, do you frequently give opening statements in your mediation? I say no, because I'm the mediator, not the attorney involved. But if you're attorney involved, answer that particular question. So, again, early neutral evaluation. And one of the things I'd like your comments on the question and answer portion, if you get a chance to, or in the chat session, is to give me your thoughts about the advantages and disadvantages, at least as you see them, with respect to joint opening statements, where you're actually making an open statement, before the mediator and before your client and your opposing party and that opposing party's client, to describe, the elements of your case and what the value is and what you think the damages are. And then typically in the Midwest, at least in my experience, nobody wants to make an opening statement, and instead they want to go to individual caucuses immediately, which I think is missing the point. From my standpoint, my own opening statement, if they're not going to make a statement, is merely to tell everybody what the rules of the game are. Exactly why are we here, what I understand the facts and circumstances are that are in dispute, that everything is confidential that is said here, and nothing that is said can be used outside of this proceeding. There's not going to be any recording. There's not going to be any cross-examination, with respect to the parties, even if you're just doing a traditional mediation, so that you get some comfort with respect to those clients to know exactly what is going to transpire. But as you'll see, I'm honestly quite a big proponent of early neutral evaluation, because I think it helps everybody and the parties to see exactly what the other side is going to say about what the case is about. Let's see here, I'll get to the next slide. So you're going to find out that this is not one of those situations where, and by the way, on the question on the poll here about whether you give an opening statement, unanimously, almost unanimously, 82% answered that they do not give an opening statement in your mediations, in your traditional mediations, which would certainly be different than if you were using early neutral evaluation. So let's talk about the early neutral evaluation. And it's going to be a little bit more time consuming than the normal traditional mediation. And we're going to go through the items to be discussed and basically what's going on here. Keep in mind, this is the preliminary session. This is the session between the attorneys and the neutral. And they're discussing, if the parties want to have a traditional mediation or if they would like to experience an early neutral evaluation. And I'm going to do my best to sell you, and I'm going to sell basically as many people as I can, that early neutral evaluation is basically the way to go, because what have you got to lose? I mean, it's still confidential. It's still non-binding. So, the benefit is that you're going to get your client to basically see what the other party has as far as elements to prove their allegations that they've asserted in the cause of action or in the complaint. So the first item on the preliminary session between the attorneys and the neutral is basically when and where will the E&E session take place? And believe me, I've experienced a lot of problems with respect to getting attorneys to agree as to when and where the E&E session is going to take place, and describing to them, obviously, what the E&E session is about and trying to get them to do it. But, our calendars are all crowded because of the fact that we've had COVID around and we haven't been able to do any in-person mediations. And some people really prefer in-person mediations. Frankly, I do. But, I've done most of the, mediations that I've done since March of last year have been done remotely through Zoom. And I found, as well as my son-in-law has found in his large cases, which are multi-million-dollar cases, that basically you're going to find that the results of, a mediation that you asked for are going to be the same, every time, whether it's remote or whether it's in person. It really, from his standpoint, from my standpoint, doesn't seem it makes any difference, because we've nailed down, in effect, the aspects of remote mediation and how you do it, into putting clients into separate breakout rooms so that they know that they have a basically confidential area that they can retreat to. We have a confidential area where basically attorneys can retreat to so that they can talk to one another, which I think would be very helpful. The other aspect of in the preliminary session that you're talking about is who's going to attend this session. Obviously, the attorneys are going to attend it. Hopefully it's not going to be pro se. That's a really difficult situation. Certainly doesn't work in early neutral evaluation. So if you've got a pro se, I don't recommend early neutral evaluation. Early neutral evaluation isn't for every case that you've got. It's probably for cases that maybe have damages that are provable in the upward of $100,000 or more. And so that may rule out some of the smaller mediation cases that you have. But you're certainly, into a situation where early neutral evaluation is appropriate for a case that has monetary values that are in addition to positive of $100,000. Who attends? You got to have somebody attend that's got authority. And that's basically set forth in the rules, is that somebody that is coming to the mediation or the early neutral evaluation, somebody has to have the authority to settle individually. Not, asking for permission after the mediator leaves an individual caucus, but somebody that has the authority to settle. And, from my standpoint, if you come to the mediation or the early neutral evaluation and you say, I'm not going to pay a dime because I don't think that the other side has a meritorious cause of action anywhere set forth in their complaint, I don't think that's good faith. I think you have to exhibit good faith by coming to a mediation or an early neutral evaluation with some degree of authority as to compensation or a reason why. Basically, what Jim O'Hara, who was the U.S. District Court magistrate for the state of Kansas, sitting in Kansas City, Kansas, has basically told me, authority means reasonable authority. So you're looking at it and saying, what would be reasonable for a settlement in this particular case? Do you have the insurers that are attending, or the insurance adjudicator or adjuster attending that has already some degree of settlement authority? That settlement authority may be reasonable in his mind. It may not be reasonable in the minds of the plaintiff or the charging party, but you must have somebody that's got some degree of authority. You have the counsel, basically the neutral tells the counsel that they have to submit a substantive written agreement setting forth the position of the respective parties, the facts, legal analysis, and calculation of damages. And in that regard, I really recommend that you go to the website of the California Federal District Court of the Northern District of California, and it's as I told you before, it's www.cand.uscourts.gov. And I would draw your attention to paragraph 5.8, which in their alternate dispute resolution, early neutral evaluation comment says, here's what should be included in written early neutral evaluation statements. And it's got a list of those things that I will not go over today, but I would recommend that you look at them. And also, if you look at their rule number 5-11, which is entitled Procedure at Early Neutral Evaluation, you will find what basically the California courts in the Northern District, at least in the Federal District Court, basically suggests, or what the components are of a early neutral evaluation session. So we've got that taken care of. The neutral explains that the written statements by the attorneys will be exchanged. I would tell you in every mediation case that I've had, that the parties send to me a mediation statement, but they make it highly confidential and direct you that you are not to provide this written evaluation to the other side. I honestly believe just the otherwise. I think if you've really done a good job in preparing your written substantive statements, that you ought to exchange them. As I mentioned to you earlier, David Sandberg told me that in all of his cases, he basically asked if the attorneys he and his opposing counsel will exchange substantive written statements. And, honestly, he said, if they don't agree, he's going to provide his anyway, because he thinks if you provide your written statement and you're citing the law and you're citing the facts as you understand them, and you have attached a proposed draft of a complaint or a petition, honestly, if you don't exchange those statements and you go into litigation, they're going to get all of that information in discovery anyway. So why not go ahead and disclose it now in your substantive written statement instead of waiting for the other side to agree? Don't mark it confidential. Mark it so it comes to your benefit, that you're showing the other side the merits of the causes of action that you've asserted, or the defense counsel is showing why they think that you've interpreted the law incorrectly and why your causes of action don't fit. In any event, the counsel deliver the opening statements. Now we're saying, we're talking about the preliminary statement, or the preliminary information between the attorneys and the neutral. And you explain to them that basically we're going to deliver the opening statements in joint session. So when you get to the joint session, rather than saying we're not going to make an opening statement, an early neutral evaluation, it's basically required that you make an opening statement. And then after you make your opening statement, both sides, each side will present the testimony of the clients and the witnesses, including the expert witnesses, if there are any. It's important that you understand these rules. There's no direct or cross-examined by the attorneys that are allowed. You can have the witnesses up there, but you don't, as the opposing counsel, get the chance to basically do cross-examination. There's no transcripts, no recording, no copying of documents. in an early neutral evaluation. After the after the opening statements that are made by the various counsel, the neutral can then ask questions of the counsel and ask them, information that they need to write down their early evaluation. No individual caucuses are permitted. I mean, that's traditional right now in the Midwest. As you go, you immediately have the counsel say, well, I don't want to have an opening statement. Let's go into individual caucuses. In early neutral evaluation, no caucuses are permitted. No ex parte communications are permitted and are strictly forbidden. After that process is done, the neutral then retires to a separate place and basically writes their case evaluation. I call that case evaluation, in my standpoint, and perhaps in yours, findings of fact and conclusions of law that you think would be appropriate if you were the judge in this particular matter. And so you write that down. I normally would ask the counsel, each of them, to prepare for me a draft of what they believe the findings of fact and conclusions of law should be based on their information and their research that they've done. That might help me in writing my case evaluation and looking at the two of them and seeing what they had to say about the various witnesses. This, I will tell you, requires a little bit of diplomacy. I mean, you can't really in your written evaluation say, well, I think your client's a liar. You have to be a little bit more diplomatic and say that the information that was presented was not persuasive, in order to change your mind with respect to the way that the case may turn out if you went to trial. So you write your findings of fact and conclusions of law as a neutral, then you come back into the joint session, you put your findings, your written evaluation in a sealed envelope, you place it on the desk, and you say to the attorneys and their parties, would you like to see what my written evaluation says? And literally at that point in time, if either one of them says they want to see the written evaluation, and then you open it and you read it. But if both of them say, no, let's wait and let's see if there is some other way to settle this case now that we've had joint opening statements that we've seen and we've had evidence presented, let's try just to go into a traditional mediation format. So you leave the sealed envelope on the table. You basically agree you're going to go into a traditional mediations, format. You can do individual caucuses at that point in time. And then if you come back to the table and basically the parties still have not been able to agree on any kind of a settlement, you basically say to them, well, I think now is the time, since you've reached an impasse, that we open up my written evaluation and read it to them. You open up the written evaluation by the neutral and you read it to the parties that are there right there in the joint session. And after you've read it, you again will then say, now that you've seen the written evaluation, would you like to try once more to see if there is a method in traditional mediation to resolve this case? And so then you adjourn and you go into basically your traditional mediation session, and try to get the settlement done on individual caucuses going back and forth. If that still results in an impasse, we've got another quick poll here. Which online meeting platform do you prefer? I'll tell you what the results are because I'll get that in a minute. The online platform that I choose is Zoom because that's the one I'm most familiar with. So now we're basically back to kind of the final stages of the attorneys telling. Whoops, let's see here. Okay. This is kind of a chart that Jennifer put together that I think is probably pretty important to review. One thing that you have to make sure in a early neutral evaluation is that you as the neutral are firmly in control, because at some point in time, there may be an emotional discharge by either the attorney pounding the table or doing something else that is inappropriate that they wouldn't do if they were before a judge. But you need to basically tell them, I'm in control. And we're expecting you to use the same demeanor that you would use if you were before a judge. You talk to them about being there in good faith, no rules of evidence. The neutral is going to give a second opinion. no direct or cross-examinations, expect the parties to be courteous to one another. If the parties decide to settle, that it's their settlement, and assuring that there is confidentiality, no interruptions, and how the same will be memorialized. And so we get to that point where hopefully we've got a settlement as a result of the early neutral evaluation. Again, it's a second opinion that is made by the neutral, that is a lawyer, and tells the parties what basically that neutral believes will be the result if they went to trial. What are the, there we go. Everybody basically was pretty unanimous. 76% of you basically said that you used or preferred Zoom, and then 12% WebEx, 12% Microsoft Teams, 4% GoToMeetings, and the rest of them options are 0. So I think that's probably pretty representative of the way that we're traditionally doing our business right now. So what are the unnecessary costs and delay that early neutral evaluation attempts to eliminate? We're trying to eliminate poor and tardy communication across party lines and between lawyer and client. I think that's obvious. One thing that would be there, as I said, sometimes the purpose of this was to make sure the clients didn't feel that they were left out in left field and didn't know really what was going on while the lawyers were transacting their business. Number 2, attempt to avoid procrastination. Right now with COVID around, there's been a lot of procrastination. Trying to get dates from attorneys have been complicated by virtue of the fact that you've got their dockets crowded because of COVID. As far as that's concerned, the judges' dockets are crowded because most of the judges now, even though they're not been assigned to the criminal docket, that basically they're concerned, as the entirety of the judiciary is concerned, about taking care of the criminal docket and making sure you don't have speedy trial issues. So those cases that are criminal cases are going to be in front of yours if yours is a civil case. Difficulty in locating the center of the case. And I always refer to that as, if you understand the center of the case, what you're really talking about is if you've thrown everything up against the wall that you could possibly think of. Some of them are going to be meaningful, some of them are not going to be meaningful. So the center of the case is basically what remains sticking on the wall, what doesn't fall off the wall. It's kind of a bad parallel, I guess, but it's one that I think is appropriate. And which you identify, hopefully, and understand which claims and which defenses are the most important. Not all of them have the same degree of importance, because what you're going to have is that the neutral, in setting their case evaluation opinion, their second opinion that they're going to give, basically is going to assign probative value to whatever is basically produced at the time of the early neutral evaluation. There's no rules of evidence, and so you can have hearsay, you can have other items come in that normally would not come in a traditional trial, that the judge would not permit to come in. But in here, you've got the neutral that is weighing the evidence based on what the probative value of. If it's secondhand, if it's basically hearsay, the neutral is probably not going to assign great probative value to that information. Unfocused and unnecessary discovery. We all know, and big items that are always of a concern is electronically stored information. How do you get to it? What terms do you require? What terms do you agree on that are going to be set forth in whoever the responding party is to providing electronically stored information? And that's all driven by a discussion and negotiation as to which terms are relevant and necessary. You try to avoid unnecessary and unproductive motions. A motion for a judgment on the pleadings or on the evidence that's presented after very limited discovery. A motion for summary judgment is probably not going to be productive in most cases. And I always said that motions for summary judgments, if they're granted, are about a 50% success rate, because if it goes up on appeal, the motion for summary judgment may very well be overturned and you're back where you were before you filed the motion for summary judgment. So hopefully you can avoid unnecessary and unproductive motions, whether it's a motion in limine, or whatever the case may be. And then other item is avoiding the difficulty in confronting a case comprehensively and objectively. And what I mean by that is that now, you know, if you're doing Title VII cases, you know, you may feel like somebody's been wronged, but there's not a remedy, you know, and you need to have done the work that is necessary that you should have done before you ever filed a charging statement or filed a petition or complaint, that you understand objectively and comprehensively what is basically the important aspect of the case. You know, I can't tell you how many times that somebody comes in and says, my case is worth $2 million. And in fact, provable damages are less than $100,000. And so that's not approaching the case comprehensively and objectively. What are the problems that E&E targets? One of them I already just mentioned is unrealistic clients. Clients who basically think the value of their case is much greater than what those of us involved in practicing law would find to be outside the normal parameters that we believe would be appropriate. You know, if you go to the jury verdict services, you may be able to find and convince your client that the value of the case is not $2 million. If it goes to trial, here are the jury verdict services on cases of similar nature that basically are, you know, somewhat similar to your case. Avoid unrealistic counsel. I mean, we're all adversaries. We all want to undertake with sincere belief and present with sincere belief the presentation that we're making on behalf of our client. And so sometimes we get so involved in that, you know, what we're going to do is not going to change the course of the Western world, period. But we get so involved in the case that we emotionally get involved in the case along with our client. And we buy into this valuation of the damages that we're going to ask for, you know, initially as our initial demand. We have clients that lack confidence in basically their own case. If you have early neutral evaluation, the client basically gets to see, you know, what they're basically confronting, and it so gives them either more confidence or less confidence basically in their lawsuit, and maybe helps you manage their expectations. You have counsel that lack confidence, you know, in their own case. And that's a problem if you're lacking confidence in your own case, because you can't convince your client that you have a sincere desire to basically win the case on their behalf. And that gets into alienating clients. And, you know, the clients are concerned that the meter's running all the time. And then the other thing that I said earlier on was the reluctance to be first to blink. What do we basically go to when we say, how do we get to mediation? And if we ask for mediation, does that mean we're suggesting that there is some weakness in our case? And that's just not the case. And I think, you know, lawyers ought to understand that anybody should, and on behalf of their client, want to ask for an early neutral evaluation so that all the cards are on the table. And this is basically my closing slide that basically said, you know, E&E serves as somewhat of a reality check for the lawyers and for clients whose ambitions for their cases or whose assessment of their position seem to fall outside the zones that most lawyers and judges would deem reasonable. So I hope in this process that you understand that there is distinct value to early neutral evaluation. I really encourage you to try it and to see if it fits. It's not, you know, for everybody. It's not for every case that you've got, but it's certainly a tool that is, you know, to some degree encouraged by virtue of the federal courts, you know, saying that this is something that your local rules should require. And it does mention early neutral evaluation, and particularly in the Missouri court, and I hope in the Arkansas courts, that basically they would embrace the thought process with respect to early neutral evaluation. Megan, I don't know how much time we've got and whether or not we've got some left, but I'm going to look now at the chat session and see if I've got any questions here that I need to answer. Oh, one panelist said I forgot to say happy Earth birthday. The video first poll is about the launch. Is the Do we have any other questions that basically people want to pose on their chat session or in the question and answer session that we've got here? I'd be happy to, we said we'd reserve some time for comments, actual observations, your experiences, why you think this might work, why it wouldn't work in your particular case, why you would object to an opening statement. I know it requires more time and it requires probably more thought, and it puts mediation in a position where it's not just another step in the process to get to litigation, but instead, you know, you take it seriously and you say, this is a case in which I can actually get something done by early neutral evaluation. All in open session, all, you know, everybody's there. It's just like you're in a jury trial or you're in a bench trial where your client's sitting beside you and your client's seeing everything that's going on. I highly encourage you to basically try it out. And if you would please send to me what you think after you heard this information with respect to early neutral evaluations and whether you think it's worthwhile or not. I've got one question here. Could you briefly restate the primary distinction between the preliminary early neutral evaluation session and the main session? I certainly can. The purpose of the preliminary session is to go through each and every one of the elements that I went through. I think there may be 18 of them or so that I set forth in the slideshow that says, you know, this is what you do. You when you're in that conversation and the preliminary hearing or the preliminary discussion between counsel, is you're really basically setting the rules and telling everybody how early neutral evaluation is going to work and making sure the counsel are on board with respect to that. And then when you get to the main session, you basically kind of repeat, you know, in a more summary format for the clients and the attorneys there to understand in the main, you know, mediation session, here's what's going to happen and here's what we're going to do. And I'm going to give you a second opinion as to how I think this case would turn out in the event of going to trial. And so in your primary session of the mediation, of the early neutral evaluation, you're basically telling everybody kind of the things that you've already talked to about the clients and their attorneys, you know, when they had their early primary call discussing early neutral evaluation and making sure that everybody's on the same plane. Question is, how are experts delivering complete opinions if attorneys do not direct or cross-examination? They don't, from the standpoint of, you know, being able to cross and find out, you know, if there is a problem with respect to that expert, but at least you know that expert is there and you know pretty much what that expert is going to testify to. You can't use that information outside the mediation, but the expert, whether it's, you know, competent or not, or authorized or not, or if the court would recognize that particular person as an expert, is somewhat irrelevant in a early neutral evaluation. You're sitting there really giving probative value to whatever you think is heard. If you think the expert is off base, you know, just basically witnessing the demeanor and the comments and the evidence that is being presented by the expert, you obviously don't have the right to cross-examine that expert, but at least you've got information as to what that expert is going to say in his opinion. So I think that's a very good question, Steve. But, you know, I think, you know, allowing the experts to come in without cross-examining them, I know is not a realistic thing, as if it were in trial and you were trying to impeach that particular expert witness. But at least you have some information that you can go with. All right. Megan, do we still have time or are we out of time here?
We are almost out of time. If you wanted to say a few more things, I think that would be okay if you'd like to.
Okay. The only thing I wanted to say is that I really do want to try to encourage some of you to try this out and see in a particular case, you know, if you think it's very valuable. I personally think it is incredibly valuable. And having done so many traditional mediation sessions, and again, some of them certainly would not fit the category of basically going to the extent that we're going to in early neutral evaluation. But I think there are cases that you have currently that you can talk to the other council and say, or in your demand letter, say, I suggest that we use that hybrid form of mediation that is called early neutral evaluation. We do a joint session. We have everybody there. You know, obviously you have some witnesses that you're going to keep out of the room and call them in when it's appropriate for them to be in there, or the same way with some witnesses, you'd follow the same rules with respect to that, not let them hear what other people have to say and have their opinions and their comments directly set forth on whatever they believe as opposed to what they may heard from a prior witness. That doesn't change anything, but it's still, you know, giving that probative value to how likely is it that this matter, what's the, you know, the probability of this being true, and write your evaluation on that, which is almost like having a separate, you know, kind of model jury trial, if you will, trying to see what some of the people that you select to set in this proposed jury, you know, think about your opinions and your comments, but it's done really more in a less expensive fashion, you know, and not getting, you know, people that act as juries to give you some comments, but you get before a neutral mediator that is trained, that can give you an evaluation and a second opinion as to your own case. And so it's another method that basically gets you on a timing basis ahead of the game. Again, I suggest and I highly recommend that you basically try it out. And I would love for you to tell me what your experiences are if you try this out and whether you like it or you don't like it. Again, Midwest typically go in, no opening statements by lawyers, go directly to individual caucuses, and then transport back and forth from room to room, trying to get the case settled. This, I think, this format is much more realistic for our opportunity, literally, to settle the case. And if you don't settle, to try to reach some stipulations as to facts, some stipulations as to electronically stored information, terms, how many depositions are going to be taken, who are going to be the deponents. You know, you could at least agree on those things that may otherwise take a lot of time to agree on without just writing back and forth email letters to each other. So I want to thank all of you for participating in this particular commentary as it relates to early neutral evaluation. That's the end of our program and the end of our time. So thank you again for participating, and I would love to hear your comments and suggestions and why you think this would work as a benefit or a disadvantage, so that we can all consider that and take them into another session that we can discuss benefits and disadvantages other than those that I've tried to point out to you today. So again, thank you, Megan. Thank you very much for administering this for us. And,
of course, and we thank you so much, Bob, for taking your time to talk to us about this today. We really appreciate you.
Thank you very much. I enjoyed it, and I hope everybody on the participant list got something of value, if nothing more than the citations that I gave you with respect to that matter. And Megan, will some of this written material or the slides be distributed to the participants?
I am not 100% sure. I will verify with Jen. The survey will be sent out shortly for feedback, and I can double check with her to see if people would like to request the PowerPoint that we would be able to send it to them. So I will find that out.
Okay, thank you very much. I'm going to sign off. And again, I say I appreciate very much your attention and your participation in this webinar.
Thank you all. That concludes the webinar for the day.